yourself on camera, you can feel free to take yourself off camera. And we are, okay, great. Thank you, Tiara. So I'm gonna hand the mic over to Cora Metric Chen. Again, she is from Take Root Justice, and she is a lawyer, and she will be presenting this training on harassment by landlords within the context of housing court. Thank you, Cora.
Hey everyone, and thank you, Nipa. So a few disclaimers about this presentation before we get started. Also, can everyone hear me okay? But just let me know if there's issues with the audio or Tara. So a few things about this presentation. The first thing is that I geared this presentation for people with no background knowledge in navigating the court system or the legal system whatsoever. I see that there are quite a few practitioners in the room. So if you are somebody with more experience, feel free to ask more technical or advanced questions towards the end. I can't promise I'll be able to answer them. Small chance you know more than I do. And if you are a person without background in navigating legal systems or the housing court, and there's something that I didn't explain well, please just let me know, flag it for a question. We'll take questions at the end. So today we're talking about harassment by landlords. And before we get into it, I just wanted to give a little bit of background about my organization. This isn't just shameless self-promotion. There's a reason I want to talk about the work that Take Root Justice does. As we go through this presentation, we're going to be talking about the legal definition of harassment. But, you know, among regular everyday people, there are different meanings of harassment. And for housing advocates or tenants' rights advocates, landlord harassment is a means by which landlords intimidate and aggravate, especially low income and rent stabilized tenants, to drive them out in favor of higher paying tenants. So to us, harassment has a certain aim and a certain context in our neighborhoods and communities. And I also wanted to flag that a landlord who is harassing you is probably not just harassing you. That person's probably harassing other people in the building too. You'll see throughout this presentation that there are a lot of reasons why folks are stronger together. And Take Root Justice in particular, our work is dedicated to helping organized tenants, such as tenants who have formed tenant associations or tenant unions in their building, get together and defend their rights in their building. So this presentation can be roughly broken down into 3 parts. The first part is going to be what we mean by harassment. What's the legal definition of harassment for the purposes of this presentation? And then we're going to talk a little bit about, in particular, HP lawsuits or actions for harassment. So you can get an idea of what that lawsuit in particular does or doesn't do, and think about, you know, is that something that could be helpful for you in your situation or in the, you know, helping your clients out. And then we're going to talk about the steps of filing an HP action. So first third of the presentation is dedicated to the meaning of landlord harassment in law. I want to center us and focus us in what type of harassment we're talking about, because there are lots of different types of harassment, right? There's sexual harassment, there's stalking harassment. We're specifically talking about landlord harassment. So of course, this is behavior undertaken by a landlord or its agents. That's like the sort of specific legal term for people who work for the landlord and represent the landlord in a certain fashion. So landlord harassment is, of course, by a landlord or its agents, and it is against a tenant or a lawful occupant. I'm going to take a moment here to define a little bit lawful occupant. The harassment laws that we're going to be talking about tend to be geared towards protecting lawful occupants. And that's the term that the harassment statute uses. So what do we mean by a lawful occupant? You can think of it sort of simplistically as somebody who has permission to live in the unit. They may have gotten permission from the owner, or they may have gotten permission from the person whose name is on the lease. What we don't mean is somebody who comes in without permission. That the law would not see that person as a lawful occupant. So by a landlord or its agents against a tenant or a lawful occupant. And there is a specific requirement in the harassment statute that for the behavior to be landlord harassment, that behavior must be intended to either cause the target to vacate the apartment or cause the target to surrender or waive rights that are related to being able to having that permission to be in that apartment. So we're going to go through and talk about some types of harassment. There are lots of different harassing behaviors, but in the eyes of the law, unless that behavior is intended to do something to the tenant regarding the tenant's rights, apartment rights, tenant's rights, or push the tenant out, it doesn't count as landlord harassment. So if we take the example of sexual harassment, there's a chance that your landlord is sexually harassing you because they're a bad person, and that's just how they are. And there's a chance that the landlord is sexually harassing because they want to drive the person out. In the eyes of the law, it'd be that second scenario that would be landlord harassment, whereas the first scenario would be better dealt with outside of housing court. We're going to go through, not in as much depth as we could, but in a little bit of depth, different types of behaviors that what I call the harassment statute, which comes from the Housing Maintenance Code of New York City, defines as harassment. I wanted to start with the most basic versions, things that the things that you read on the list of the many things that the Housing Maintenance Code defines as harassment, the things that you read and you're like, oh yeah, that sounds like harassment to me. Again, these behaviors are considered landlord harassment under law if they are against a lawful occupant by a landlord or its agents. So some obvious ones: using force or threatening to use force, removing the person's possessions from the unit, removing or interfering with the door or the lock without giving a new key or like a new means of accessing the apartment. And then there's sort of the type of harassment we think of as like repeated unwanted contact. If the person, the landlord or the super, is contacting you at odd hours, before 9 a.m., after 5 p.m., on the weekends, on holidays, or if they're just contacting you a really unreasonable amount of times with like at a really unreasonable frequency, these are all included in the definition of harassment under the Housing Maintenance Code. And I think that's not surprising or hard to understand. I wanted to move along to some things that are maybe a little less intuitive. So over here in the pink column, we have miscellany of other behaviors that are considered harassment, landlord harassment under the Housing Maintenance Code. Some of them have to do with protected categories or, lawmakers trying to protect specific groups. So this is not a complete or exhausted list, but people who come under certain identity categories, if the landlord is threatening a person based off of these categories, then that's considered harassment. So among the many, some are age, race, immigration status, sexual orientation, source of income, and a status as a victim of a sex offense. And to just give a little bit of detail towards those last two that I pulled from the list, source of income could mean, do you receive Section 8? Or do you pay for your rent in part with FEPS or city FEPS? Or are you on DRE or screen? And status as a victim of a sex offense could mean, if your landlord is threatening you because there is somebody who has been abusing you coming around, then that's also considered landlord harassment. If the landlord is using your status as a victim to threaten your rights as a tenant, that's also considered landlord harassment. And unfortunately, that's something that we see pretty commonly, where people who are already experiencing a really hard time, it just sort of piles up because of the landlord's response to it. So this one regarding the ID is intended to protect people who may not have access to many different forms of government ID, either, usually because of their status as an immigrant. So if you've already given a landlord a government issued ID and the landlord's like, well, you need to give me a US passport, that's considered landlord harassment. And then there's also protected, behaviors that the law protects against by considering them landlord harassment that have to do with false information. You'll see this elsewhere on the list too, but giving the occupant or tenant false or misleading information regarding the occupancy of the unit. So if the landlord is lying to you about who lives in the unit, or who can live in the unit, that can be considered landlord harassment. And then the last one is if the landlord repeatedly sues you in what the law calls baseless or frivolous lawsuits. So unfortunately, the courts have not been very generous or open with deeming certain lawsuit-related behaviors as falling under this category. If the landlord is serving you with lots of different rent demands, but hasn't sued you yet, that isn't quite going to cut it under this definition of harassment. And if the landlord has sued you multiple times because you've fallen behind on rent multiple times, there's a chance that the court still won't see it as harassment because the court might be like, well, you've fallen behind on rent, so these multiple lawsuits are not baseless or frivolous. Courts, the judges have been kind of strict in defining what they think is baseless or frivolous, and have often required that the previous, that there be at least 3 of them, and the previous 2 got dismissed or discontinued rather than settled, for instance. If there are other repeated baseless or frivolous lawsuits in the building, and you find out about them by talking to your neighbors, by organizing, by doing some research, then just one baseless or frivolous lawsuit against you might constitute landlord harassment. And I am giving this cautionary information not to dissuade people from trying to claim that related behaviors are harassment. I think it's really important to try to convince judges that landlord harassment is landlord harassment. I just want people to have a sense of, what they're up against and the possible obstacles. There are a lot of repair and construction related definitions of harassment. Ones that we deal with most often as tenants' rights lawyers and advocates are repeated or extended disruptions of essential services or repeated failures to repair Class B or C violations. Often, when tenants sue about this type of harassment, they're doing a dual lawsuit that both is trying to get the landlord to do the repairs or restore the services and alleging harassment. And what we've seen is that judges are maybe more comfortable with ordering the landlord to do repairs and maybe a little less comfortable or less quick to deem that behavior harassment. And I mentioned this later on in the presentation, but if you're bringing a a repair related harassment charge against the landlord, you are definitely going to want to get, by calling 311/HPD, you're going to want violations placed in the building to back it up. Just running down the list of other repair related definitions of construction, repeated false certifications of a violation as repaired is harassment. Work without a construction permit when, the construction permit is required for the work. Failing to correct conditions that underlie a vacate order. So if there's a vacate order on the building that says to the landlord that they have to fix certain conditions before people can come back to the building, and the landlord doesn't, that can be considered harassment. And then if the landlord is, making applications to government administrations to do work in the building and is lying about the rent stabilization status of a unit in those applications, that's also harassment. Finally, we've got buyout related definitions of harassment. The landlord is not allowed to contact you to buy you out of your apartment unless they give you certain notices with that contact. And the notice has to include that you have a right to a lawyer, that it is they, the landlord, who's contacting you, and that you are allowed to refuse the buyout offer, along with some other information. Failure to do that can be considered harassment. And even if they do all of that correctly, if they reach out to you with all of that information and tell you they want to buy you out, and you write back to them and say, hey, please don't do this. I don't want to hear about buyouts. As long as you do that in writing for 6 months afterwards, they cannot contact you whatsoever about a buyout. And if they do contact you again about a buyout within that time period, then that's harassment. And finally, here are some behaviors that we might think should always constitute harassment, but don't necessarily, unless the landlord is doing them while also offering to buy someone out. Using intimidating or obscene language, contacting you too much, contacting you at your workplace, or giving you false information. And then, now that I've laid out all of these really, really specific meanings of harassment under law, I'm just gonna sort of like explode all of that and say, there's also a catch-all. And so any behavior that's repeated and significant and substantially interferes with the occupant's peace and quiet and is by a landlord against an occupant can be considered harassment. Sorry, I have seasonal allergies, so my voice is kind of going. So everything we just ran through comes from the Housing Maintenance Code. It's the legal definition of harassment in what we call the New York City harassment statute. Give me one moment, I'm just gonna cough it out, sorry. There's also a definition of harassment specifically for rent stabilized tenants or people who live in rent stabilized units. The rent stabilization code itself has its own separate definition of harassment. I'm going to assume that people in this presentation know if they're rent stabilized or not. If you don't, I'm sure there's a lot of other trainings out there that can help you sort that out. But assuming that you know you're a rent stabilized tenant then the rent stabilization code has its own definition of harassment and offers you an alternative way to file a harassment claim against your landlord. Instead of being heard by a judge in housing court, you can be heard by the administrative agency that runs rent stabilization, DHCR. And you can do that simply by filling out a particular form, RA60H, you can find it online, and you mail that form to DHCR or you bring it to the DHCR office. DHCR will schedule a hearing, and similarly to with the housing maintenance code definition of harassment, if DHCR finds harassment, it will fine the landlord. But I'm not going to get into the rent stabilizations code definition of harassment very much in this presentation, because we are going to focus on housing court and HP actions. So we just went through a long list of behaviors that are considered harassment. Let's talk about some things where you might have to get a little bit creative to convince a judge that it's landlord harassment. And this is a place where, one of many places where I find that the law kind of falls short of really implementing justice for people. As housing advocates, we see a lot of instances where landlords are extremely disrespectful and patronizing to tenants. And tenants understandably would like to be able to tell a judge, this is how my landlord's behaving towards me, and that's really messed up, and have the judge agree. I think that folks should try it. We think that folks should try it. And you're especially likely to get the result that you want out of trying a case like that if you've teamed up with other tenants in your building. But just to flag some things that don't necessarily fall under the legal definition of harassment, when the landlord is arguing with you and there's no threats of force or use of force, the landlord using swear words with no offer of a buyout, the landlord being rude to you or disrespectful, the landlord insulting you, and the landlord sending repeated notices about you owing rent. We really encourage tenants to try to be creative about what type of harassment claims they bring. And this is not to discourage people from bringing them, but just to flag what might be sort of like problem areas that take more planning, more creativity, and more dedication when bringing the case. Okay, so that covers the first third of the presentation. And I'm hoping that by now people have a good sense or a better sense of what is or isn't landlord harassment in housing court. Now I want to introduce HP actions for harassment. People might have encountered the term HP action previously because that is the name for the type of lawsuit that tenants can bring when they want the landlord to do repairs in their building or in their unit. There is also an HP action for harassment. In other words, HP action is the name of the type of lawsuit that a tenant brings in housing court for harassment or for repairs. Of course, in this training, we're focusing on harassment. Just a flag up front, HP actions are good for an order from a judge to tell the landlord to stop their harassment. That's the main thing that is in law, the point of a harassment, of an HP action for harassment. HP actions are not as good for compensation for the harassment that you've suffered. And they're especially not good for compensation if you have personal belongings that are damaged or destroyed. And I'll talk a little bit more about why that is. There are mechanisms for getting a little bit of compensation, but you'll see that that can be difficult and limited, and it can come with downsides. Okay, so what can you get out of an HB action for harassment? That very first thing I said, an order from a judge telling the landlord to cease the harassing behavior. It's also called an injunction or injunctive relief. Um, and then in addition to that order, the judge will order the landlord, if the judge finds harassment, the judge will order the landlord to pay penalties to the city. Under the Housing Maintenance Code, the penalties that the landlord has to pay upon a finding of harassment are $2,000 to $10,000 per apartment. Again, just to be really clear, civil penalties, the meaning of civil penalties, this is not money that the person suing gets. This is the money the landlord has to pay for violating the law to the city. The minimum amount goes up if the landlord has been found to have harassed somebody previously. So then the minimum amount is 4,000 instead of 2,000. You can also get compensatory damages out of a harassment case. The tenant or the person bringing the lawsuit gets to choose, do I want $1,000 or do I want compensatory damages? On top of that, they're also supposed to be able to recover attorney's fees. This is if you win the case. Compensatory damages are tricky in law because you have to be able to prove that you actually suffered a damage of that actual amount. So saying, well, this thing really affected me emotionally and psychologically and made it hard for me to work is not going to be sufficient usually to get compensatory damages. This is usually going to mean things more like showing receipts for paying extra for electricity and to buy electric heaters when you were without heat the entire winter. Or like bills when you had to go to a doctor if the landlord like physically hurt you. Things that you have receipts for and that the accounting for is very clear. Again, we always encourage tenants to go for more, to try to get more, to tell the judge their story and to convince the judge to see it their way. But just sort of outlining the legal bottom line. And it's also possible to ask the judge to impose punitive damages on the landlord as well. Punitive damages are money that the landlord has to pay to the person suing as a punishment for their behavior. So the behavior for the judge to award this is going to have been pretty bad. Why not ask for it? This is everything in yellow here is something you could get from winning the basic harassment case. If you get an injunction, an order from the judge, and the landlord violates the injunction, then you have a chance to get additional things out of the harassment case. Again, you can get actual damages / compensatory damages for the landlord's violation of the order. But if you try to get this, you waive your right to sue in personal injury for those damages. So that's just something to be aware of. Plus, you can get costs and expenses. You can recover your costs and expenses for the violation of the order. You get a statutory or, written into law $250. And so there's another chance to get punitive damages imposed on the landlord too. You're probably more likely to get punitive damages imposed on the landlord this time around once there's an order and the landlord violates the order. Okay, so what does that mean? We're going to talk about that in a few slides later, and hopefully that will become a little clearer. But what I wanted to do in this section is help people think about, the pros and cons of a harassment case and how strong their harassment case is. So I wanted to lay out a few factors that might help you win your harassment case. So all of those behaviors and acts that we talked about in the first part of the presentation, it's going to help you a lot if the harassment clearly falls into one of those categories, rather than falling into the catch-all, or falling kind of outside any of them. That, again, you can still try to bring it, and we encourage you to do it, but it will be a more open and shut case if it falls into one of those categories more clearly. The second one, this is kind of a weird one, and it's unfortunate, but the way that the harassment statute or the housing maintenance code is written, you are more likely to be able to win your case if you live in a multiple dwelling in a building with 3 or more units. The law makes it easier for those people to, or people who live in those units, to win their case. If you live in a 2-unit building, you can still make a harassment claim. You're just going to have very, very clear evidence of the fact that the landlord was trying to do whatever behavior that they did to try to get you out of the unit or to surrender your tenant's rights. So that's just something to know. If you live in a building with 2 or more units, you'll want really clear evidence, not only of the fact that the behavior occurred, but of the fact that the landlord was doing it to try to get you to surrender your tenant rights. It's also, maybe this is no surprise, gonna be easier to win your case if you're willing to testify and show up to court. And this is one of those things that's much easier said than done. Court dates are scheduled pretty randomly, and they're almost always during the workday, depending on your work schedule. They're gonna fall during a weekday, during working hours. And so this is something that's really, I think, unjust about the court system. How is the average person supposed to be able to fight for their rights in court when they're scheduled this way? If you are willing to make those sacrifices and show up to court time and time again, it's going to make your case a lot stronger, and it's going to come together a lot better. So is teaming up with other tenants in your building. If the judge sees a bunch of people from the same building coming before the judge and saying, look, judge, this is really serious, that's going to be pretty convincing. Plus, teaming up means that, you know, if you've got 5 of you, 3 of you can go to a court date one day, 2 of you can go to a court date the next time. So it just makes it easier. And finally, having proof. I'm going to talk a little bit more about different types of proof, but having evidence of the fact that the behavior occurred and of the landlord's intent to harass you is going to really help you win. Courts highly favor proof that comes from other areas of the government. And I mentioned this before, but if the harassment is related to a physical problem in the building, HPD violations or Department of Building violations are required. You'll have a chance to get an inspection to have those violations placed at the beginning of your case, but starting to call 311 now or contact DOB now to get violations placed so that there's a long history of violations is going to really help your case. I'm going to take a second to blow my nose because of the allergies. 1 second, sorry. Okay. And then finally, another consideration when thinking about filing an HB action for harassment is, what about retaliation? Everyone in the room should know that for 1 year after you stand up for your rights by either asking your landlord for repairs or calling 311 or HPD to report a repair problem or filing a lawsuit against your landlord, if your landlord within that 1 year period tries to put you out by evicting you, you have a defense to that eviction lawsuit. You can write on paper and say this lawsuit shouldn't go forward. It is illegal retaliation for my exercise of my tenants' rights. This is written into law and is a right for all tenants. This is another one of those things that might be a little bit easier said than done. If the landlord can come up with a plausible and not retaliation reason for evicting you or refusing to renew your lease or whatever, then it is harder to prove that the eviction is in fact retaliatory. So if you fall behind on rent, a lot of judges are not willing to see a lawsuit for non-payment of rent as a retaliatory lawsuit. But on the whole, what the existence of the definition of retaliation means in law is that if you formally stand up for your rights and create a written record, then you have a protection for 1 year. So this, in some ways, is a good reason to stand up for yourself, right? A landlord who is harassing you is probably trying to get you out anyway. They might try to evict you anyway. If you have called 311 to report repair problems, or if you've started a lawsuit, then you have a chance to say that if they try to evict you thereafter, it might be because they're retaliating against you. Okay, we are in the last third of this presentation, where I'm going to go through how to start an HV action, what you can expect from an HV action, and what the sort of steps are. I want to really clarify that there are two endings that are possible for a harassment case. The first ending you're always going to get. The second ending you might have to try to get. So besides having a typical beginning, middle, and end, a harassment case or any type of HB action might have a second end too. Ending number 2. The beginning is, of course, you file the papers. If the harassing behavior is related to a physical problem in the building, you can ask for an inspection from HBD or 311. So you'll get your inspection. And I'll talk about this more later. You have your first and maybe second court date. There's time for the landlord to answer. And you can also request an interim order from a judge. I'll talk about this later. In the middle, there's your further court dates. You might be having trial. You might be trying to negotiate a settlement. And at the end, if you win, you either settle for something that you want to settle for, or you're like, no, I don't like any of the settlement offers, I'm going to trial. So you go to trial and you get a decision after trial. You win or you lose. If you win, you get an order from the court. And this is when a lot of people bringing HP actions sort of walk away and assume that they killed the harassment dead and that it's dead forever. But I put a picture of this beautiful zombie here because not all harassment dies after the first time that you win your case. Some harassment has to die twice, right? You went to court for harassing behavior. You won, you convinced the judge that it was harassment. The judge ordered the landlord to stop that behavior. And guess what? The landlord kept doing it. You're in a situation where technically you won your case and there are no more court dates. And a lot of people will just walk away from the case at this time, not knowing any better what is there left to do. The landlord violates the order. You can file to hold the landlord in contempt of court for violating, a court order. And we're going to talk about this a little bit more too, but I just want people to have a really clear image in their minds that there's the end of a harassment case, and then there might be an additional step after that. Okay. And for people, sorry, but for people in the room who have actually tried doing harassment cases without a lawyer before, or even with a lawyer, and found that maybe it didn't really do much for them, the fact that you might have to follow up on the order that you get by filing for contempt might be part of why it didn't do as much. Knowing this extra thing about contempt can help make the HP action more effective. Okay, so what's step one of getting together an HP action for harassment? You have to gather up your evidence. What are some types of evidence? As I said, judges are really interested in records from other areas of the government. So from HBD, from DOB, so on. Oh, I'm not sure what this says. I think there's a copy and paste here from something else. So ignore that middle point that says living in a building with 3 or more units. If the harassment involves force or threats of force, you might want to get a police report. I put an asterisk by this because for exactly the same people that landlords tend to target with harassing behavior, the police are not always the best agency to turn to. And we need to acknowledge that. And I personally have had clients who tried to go to the police for police reports and were themselves incarcerated simply for trying to make a report. So this should be like a triple asterisk, actually. A police report can be good evidence of threats of force or force itself if making or a police report or interacting with the police is safe for you to do. And that's a big assumption. But again, generally speaking, government records of some kind are favored by the court. And then written records. So every time you talk to your landlord is probably pretty savvy. They want to talk to you in person or on the phone. Try to text them so that you can take screenshots of those texts and have a written exchange. Email them, save letters that you got from them, make note of how you got those letters or how you sent them and what days, what times. If I always say that if even if you have one of those savvy landlords who refuses to do anything in writing, one thing that you can do is just follow up with them in text or email, whatever feels most natural afterwards, and be like, just to confirm what we discussed over the phone today, this and this thing. So that at least there's something written that memorializes what was said verbally. Video. A video is a great alternative to a police report of, a specific incident. When you don't want to talk to the police or, it's not safe for you to do so. And finally, testimony. Don't underestimate the power of testimony. When you go to court to testify, you are making a sworn statement before a judge under the penalties of perjury. And a judge, if they find you to be a credible witness, which is to say, if you're not lying or covering something up or being really inconsistent, they'll find you credible. If they find you credible, then they're going to credit your sworn statement. You can't testify about something somebody else said, but you can testify about things that you experienced. Okay, so step 2 is actually starting the HP action. This is a slide with a bunch of words on it because there's a lot of steps and there's a lot of information involved in this step of filing the HP action. Basically, to file it, you're gonna have to go to court. So you can download some of these forms online, but it might be best to just go to court, stand in the long line. You go to the housing court in your borough. So every borough has its own housing court. Some of them are the same building as the civil court, some of them are different. You go to the landlord-tenant clerk's office in the housing court, and you tell the clerk that you want to start an HP action for harassment. The clerk will have you fill out a number of forms. An order to show cause is the name of the main type of form. You might also want to fill out a fee waiver form. If you don't, you're going to have to pay $45 as a filing fee. The court will not accept credit cards or personal checks, so bring a money order or cash. If you are wondering if you qualify for the fee waiver, if you receive public benefits, you automatically qualify. In addition to filling out the fee waiver form, you might also fill out an inspection request form if, again, the harassment is related to physical problems in the building. So if you're bringing a failure to make repairs harassment claim, or a failure to provide essential services harassment claim, you would request that 311 come to the building and check off, yes, in fact, there's no heat, or there's no electricity, or there's a big hole here. So with harassment HPs, you also fill out a form explaining the harassment that you've experienced. You're going to want to fill out this form. You don't want to put all of the information, every single thing. You don't have to do that. You might not want to give away all those details, but it needs to be detailed enough that it's plausible, that you're not just saying, yeah, my landlord harassed me. Yeah, my landlord used force. You're going to want to be a little bit more specific than that. When in doubt, err on the side of more detail rather than less detail. So the forms are the order to show cause, maybe the fee waiver form, maybe the inspection request form, and the housing court clerks, I'm pretty sure, give out a form specifically for harassment. If they don't give you this form or tell you they don't have it, then you want to write your own statement to file. You give all this information back to the court. The court goes and gets a signature from a judge and 2 dates for you, maybe. If you request an inspection, you get an inspection date. That might be a week from the date that you are in court filling these things out. And you'll get a court date. That might be 2 weeks later. The time really varies depending on the court's schedule. If you emphasize that it's an emergency, if it's the dead of winter and you don't have heat, the court might expedite it. So you can expect to have a court date maybe 2 weeks from the date that you're in court filing the papers. Within those 2 weeks, or before the time that you have your court date, you have to serve the papers that you filed on your landlord yourself. If you miss this step, then the judge is going to kill your case or consider your case already dead. So how do you do that? The clerk should give you very specific instructions on how to do that. Make sure you follow those instructions. You can find your landlord's names and addresses by looking them up on HPD Online is what I recommend. You look up your address in HPD Online, you look at the registration information, and you see all of the names associated with the building and the addresses. There will be an owner, a managing agent, and addresses. Each person gets 1 copy, even if they are at the same address. So you got to do this really meticulously. You have to serve the forms by certified mail. So go to the post office, ask them how to do a certified mailing, and keep all of the receipts. You get a receipt to show that you paid, and once the mail is given to the recipient, you should also get a certified mailing receipt. If you are missing the certified mailing receipt, the judge might dismiss your case. So you have to make sure you take care of service before your first court date. And that's how you get started with an HP action for harassment. On your very first court date, it's possible that really drastic things will happen. It's possible that nothing will happen. You will not have your harassment case heard, except in really unusual circumstances on the first court date. One of the first things that the court will do is if the landlord is not there in particular, the court will make sure that you serve the landlord correctly. They're going to ask for your proof of service, and if it's wrong, they might throw the case out. You'll have to start over. If the landlord isn't there, you can ask the judge to issue a default judgment against the landlord. Landlords do this to tenants who miss their eviction court dates all the time. The court might not be very willing to do that. They might just schedule a new time to give the landlord a chance to be there. It's possible the judge themselves might not be there. This happens sometimes. You'll get a new court date. I just want to highlight some of the reasons why it's possible not much happens on the first court date. It's also possible that, again, if you didn't serve correctly, that the case gets thrown out. If both sides are there, assuming everything goes well, you did the service correctly, both sides are there. The judge might be like, well, is there any way that you can work this out? And encourage you to discuss with each other to come to some sort of settlement. The judge will probably also give the landlord a chance to respond to the court case that you filed if the landlord hasn't done so already, and they probably won't have done so already. So basically, they're giving the landlord a chance to answer your court case. And you can expect the court date after the first court date to be in maybe like 3 weeks. Again, it really depends on the court's schedule. I think something that I might have forgotten to flag here is that you can also start asking the judge for what's called an interim order. This isn't a final order. It doesn't make a finding of harassment. It's just saying whatever you came to court to say, to talk about, whatever harassing behavior is at issue here, you can ask the judge to do an interim order saying, look, we're not saying the landlord is doing this. We're just saying for the duration of this case, the landlord cannot do this. So, you could get an interim order where the judge says the landlord must provide heat and hot water for the duration of the court case. So that's something that you can ask for at the first court date too, assuming both sides are there. And you can continue to ask for it if the judge doesn't give it to you. It's an interim order, so once you get your final order, you're not going to need an interim order anymore, of course. But up until that point, you can continue to ask for it. After the first court date, you should be ready to show the court your evidence. Harassment cases will move faster than cases for repairs. If you can't work it out with the other side or don't want to, the judge might send you to trial pretty quickly. So be prepared with your evidence that you should have gotten ready before the beginning of the case and have continued to gather throughout the case. Honestly, on your first court date, but be really ready on your second and third court dates. Okay, so that's kind of like the middle of the case. And what does it mean to win the case? You can come to a settlement agreement. You can come to a settlement agreement at any point up until the judge issues a final order. So even if you're in trial, you can reach out to the landlord to settle or vice versa. A way that a settlement agreement might look is the landlord says something like, look, we're not admitting that we did anything wrong, but like, we agree not to do it, whatever it is you're saying, for a certain time period. And you can say, well, if you're not admitting that you did it, maybe you don't want the settlement agreement, or maybe you say, well, if you're not admitting you did it, then at least say that if it happens again, that's automatically considered harassment. That's just one of infinite variations of a way that a settlement agreement could look. You could even have the landlord settle to agree that they did harass you. It's up to you and what you want. You don't have to settle if you don't want to. Instead of winning by settling, right, we're assuming you're only going to settle if you get what you want. And so that's a win. Instead of winning by settling, you can go to trial. You can ask the judge for an order telling the landlord to stop. You probably have to go to trial to do that. Or you have a hearing if there's enough evidence that's just on paper. You might not have to go to trial, you might just have a hearing. Less than trial, not as much testimony required. Either way, you're going to have to show your evidence to the judge, and if the judge follows along and agrees with your evidence, agrees with your reasoning, you'll get an order. So those are the two different ways that you might be able to win your case. Both a settlement agreement and an order have the same seriousness in the eyes of the law. They're both considered orders of the court. So what I was talking about before, the chance that the landlord will violate the order, that applies both to an order from a court after trial and a settlement agreement. If you come to a settlement agreement and the landlord violates it, you can still hold them in contempt of court. So we're almost at the end here. What is contempt of court? How do you go about this? The landlord violates the order of the settlement agreement. You won't be having any more court dates. You settled. The case gets taken off the court's calendar. This is, I think, a big part of why people forget about the case or don't understand that there's more that they can do at that point. People might think, oh my God, like I'm right back where I started and I have to start a whole new case. If there's a violation of the order or the settlement agreement, even though you don't have more court dates in the case that you filed, you can go back to the clerk's office at housing court and ask to file an order to show cause to hold the landlord in contempt of court. The idea is, whether it's a settlement agreement or an order directly from the judge approved whatever the thing was. And so you have a judge approved agreement and the landlord didn't listen. That is considered contempt of court. So you go back to the clerk window and you file an order to show cause to hold the landlord in contempt of court. And your case will get put back on the court's calendar. You'll have a new court date. Think about what type of proof you can present to show the fact that the landlord violated the agreement, right? It's not going to help you very much if all you can do is just say to the judge, well, the landlord violated it. It might work. Again, might as well try, right? Because your sworn testimony might be more credible than the landlord's sworn testimony. But think about what type of proof you can gather to show the fact of the violation too. And like I said, when I was talking about what you can get out of an HB action, at this point, you have another opportunity to ask for compensation for the costs or damages that you suffered because the landlord violated the order. You can ask for punitive damages and are more likely to get them at this point. That's on top of the civil penalties that the landlord might have been fined when the judge issued the order, and you can ask for civil penalties again. So you see why there's sort of like there's two endings of a harassment HB action. Okay. Hopefully all of that was clear, and I'm not going to regret not taking questions during the presentation. As I said at the beginning of the presentation, if you are a practitioner and this information wasn't advanced enough, I'll try to answer more specific questions, but you might know more than I do. If you're a tenant and some of this wasn't clear or doesn't match with your experience, I'm happy to hear your questions about that. We can see if we can make it line up or be clearer. Just wanted to share some resources in the last slide. There's the URL for HBD Online, This is a good place to try to look up your landlord to see who you need to serve to start your HP action. If you're curious about your building, you can also look up your address and who owns what.nyc. Met Council on Housing has a really good comprehensive guide on how to start an HP action. It's not specific to harassment, but it will help you understand the basics of filing an HP action. And DHCR has a fact sheet number 17, about what harassment means for rent-stabilized tenants. Remember, that's that slide. I didn't spend much time on it, but there's a separate definition of harassment available for rent-stabilized tenants and a separate way to file a harassment complaint. So if you look at the DHCR fact sheet 17, it's available online. You can figure out how to do that complaint. And again, it's pretty simple. Okay, I'm gonna stop for questions. I'm gonna stop. Should I stop sharing? I'll stop sharing because it's confusing.
Okay. Thank you, Cora. So I will ask some questions. Just remember, everyone, that this training is the focus on harassment. If you have other questions relating to like holdovers or non-payment cases, that's not the focus of this training. Um, but I will ask the questions relating to harassment. So the first question we have is, can sloppy repairs be claimed as harassment?
Okay, and I actually see a question right above that by the same person too. Is that right, Nika? What is,
Yeah, I was a little confused about that question, so I was gonna say for
let me
that.
try to take the SCREE or DHCR order question first. Hold on. Is
Okay.
there a law when the landlord or their rep refuses SCREE or a DHCR order, and where can you report the issue? Um, so I I think there's a chance you could try to argue that the landlord's refusal of SCREE is harassment. I'm not 100% sure that receipt of SCREE is source of income. A judge might see it more as the landlord's participation, voluntary rather than mandatory participation in a program. But as with the rest of this presentation, I would encourage a tenant to try it. Remember that there's a specific definition of harassment that has to do with threats regarding threatening a tenant regarding their source of income. So it wouldn't rise to the level of harassment if the landlord is merely refusing it, but if the landlord is making threats regarding somebody's receipt of SCREE or DREE, I would argue that that could be harassment. There's a totally different source of law and type of complaint for source of income discrimination. It comes from New York City human rights law, and it's not something that we're talking about in this presentation, but I would encourage you to contact the New York City Commission on Human Rights to find out more about source of income discrimination when it comes to SCREE. DHCR order, like that is going to not fall under the housing maintenance code harassment statute that we were spending most of our time talking about in this presentation. DHCR might have their own understanding of either harassment or other parts of the law where they could follow up with a landlord's violation of a DHCR order. But again, I see why these two topics are related to what we talked about in this presentation. They both potentially fall under slightly different areas of law. And then the second question was, can sloppy repairs be claimed as harassment? This is such a good question because one of the main types of harassment that we see is failure to make repairs. And Um, the reason why there are repeated failures to make repairs is because the landlord comes in and quote unquote fixes something, and the fix doesn't stay, right? Like the thing is still a problem. The leak is patched over and it leaks again in 3 months. Um, the wall is cracking, it gets painted, then the crack breaks through the paint. Um, yeah, like for us as housing lawyers or tenants advocates, the answer is very much yes. Sloppy repairs can be claimed as harassment. Your landlord is going to say, well, I tried so many times to fix it. I made a good faith effort to do this repair and it's not harassment. And so you're going to have to stand really firm. This is again why it's more powerful to do it as a group and say, these repairs are so inadequate, they cannot be counted as good faith efforts to do the repairs. Look at how bad this is. Look at how many times the problem came back. Okay, Nipa, do you want to go through other questions?
Yeah, so if your landlord accuses you also of renting elsewhere and target also that building landlord and you are never a tenant there, what is this called? What is the law name on this subject?
Okay. Sorry, I'm just taking a moment to parse this. So I assume that this is coming up in the context of being a rent stabilized tenant. Forgive me if that assumption is wrong. Um, there's no reason for there are two reasons for a landlord to care whether or not you're renting somewhere else or to make accusations about that, even if you're not. One is because you're a rent stabilized tenant, and if you're renting somewhere else, you no longer have a right to your rent stabilized unit. And the other might be because it's a violation of your lease. Either way, if the landlord can prove their accusations, you might be at risk of losing your lease. Um, so if you are rent stabilized, I would look into the law regarding non-primary residency when it comes to rent stabilization. And if you're not rent stabilized, I would double check your lease to see what the lease violation is. From like my view on this as somebody who's maybe too legal minded is that, you know, it doesn't really matter what the landlord is doing about this, um, unless they're actually filing a court case to try to get you out of your apartment. And if they are, and you're not living there, then you have a defense. But if the landlord's behavior about this particular issue rises to the level of harassment, falls into one of the harassment categories, or you think it's so disturbing that it falls into the catch-all, you can try to bring a harassment claim about it.
So the next question is, what about the landlords purposely not doing repairs? So tenants lose Section 8, so they have to move out.
Yeah, that's really interesting and messed up. Um, so with Section 8, the building has to meet certain certain quality standards. And when the landlord fails those inspections because the apartment isn't at the standard that's set, then usually what Section 8 does is suspends the subsidy that the landlord is receiving until the landlord agrees to do those repairs. But if your subsidy is suspended indefinitely, then Section 8 might stop letting you rent in that apartment, period. Um, I don't know much about this area of law when it comes to how it interacts with Section 8 in particular. And something that this presentation didn't touch on at all, and I wish I knew more about, but I don't have much to offer on it, is that there are also definitions of harassment that are specific to Section 8 too, and there's certain ways to file harassment that are specific to Section 8. An important thing to note is that if you're bringing an HP action for harassment against your landlord, you're getting Section 8, you probably need to serve the agency that you get Section 8 from. So that's probably NYCHA or HPD. So I'm just gonna default to what I've been saying all along, right? Like I really encourage tenants to try to characterize bad landlord behavior that's clearly intended to try to push somebody out as harassment and try to bring a case about that. Repeated failures to do a repair is a very clear and straightforward definition of harassment. And this thing about Section 8 could be, your speculation about, how it's connected to the landlord's intent to push you out. Yeah, hope that answers that question.
The next question we have is, if your landlord is asking you to move to another building within his list of buildings, but the unit is not a rent stabilized, is that harassment? Is he trying to displace me so I can lose my stabilized status so he can evict me easily?
So one of the things that we talked about as harassment has to do with like buyout offers, and I can see how this is almost like a quasi buyout offer. I personally think that it's inappropriate for your landlord to be contacting you about this without the requisite statement of your rights, right? This is some sort of offer where you give up your rent stabilized unit. The landlord should be informing you in writing that you're allowed not to accept the offer. You're allowed to consult an attorney about this and specifically give you the name of the person who's making the offer. I would recommend following some of the procedures that are suggested implicitly by the harassment statute. So you can try informing the landlord in writing that you're not interested. If in fact you're not interested, and if the landlord continues to contact you about it, that's just another basis to sue for harassment because they're violating the part of the harassment code that says you can't contact somebody after they inform you in writing that they're not interested. Generally speaking, rent stabilized units have a lot more protection than non-rent stabilized units. The law on that has very recently changed, so that if you live in a building owned by a landlord who owns a number of units or a number of buildings, you might have some protections, but generally speaking, the reason why there's law about buyouts and rent stabilized apartments is because rent stabilized apartments are really valuable because your tenancy has a lot more protections there. So I think that your instinct to be cautious about moving to a non-rent stabilized unit is probably a really good instinct.
If a landlord is coming at you for overdue rent, but other tenants are in the same building or getting a free pass and not pressure, is that harassment?
To me, on first glance, that seems more like an instance of discrimination than of harassment. I think that you could try it, but you would need proof that other tenants are in fact behind and are in fact receiving different treatment. And it also depends on what it means by like the landlord is coming at you, right? Are they just sending you notice that your rent is due? Are they contacting you at odd hours? Are they contacting you like absurdly frequently? Or is it, just enough that maybe you could try to say that it falls into the catch-all of the harassment code? In any case, you can try it, but it seems more obviously a case of disparate treatment or discrimination. And if you think that that disparate treatment or discrimination is possibly based off of a protected status or a protected class, like your race, your age, your source of income, et cetera, that's something to contact the New York City Human Rights Commission about.
The next question is there an expiration on collection of damages that the tenant has one awarded by a judge? Judgment was awarded more than 4 years ago, but never collected or received. Building has since changed owners.
Ooh, Bev, I'm going to have to do some research about that one. Nipa, is there a way you can facilitate collecting Bev's information so that I can get back to Bev on that?
Sure, I can definitely.
Yeah, that's a really good question. Is there a statute of limitations? And is there any mechanism that would mean that the judgment follows um, the current owner of the building? Probably you'd have to collect it from the previous owner, not the current owner. Um, Let me double check because I don't want to answer having no sense of what the answer might be. If other housing advocates or lawyers in the chat feel like they happen to know the answer to this, I will not feel offended if you want to jump in.
Yeah, if the person who answered that question, if they can just message me your contact information. If you don't know how to do that just to myself, I will message you. The next question is, can you file a case due to hardship where you are taking time off without pay to get repairs, but because the landlord is not fixing the place properly, issues returned and constantly have to be back and forth in housing court? All this is a waste of tenants' time and energy, and this is a setup to frustrate the tenant and no real effect on the landlord, who always have their crooked attorneys representing them and don't tell the truth.
I see. This sounds like a really hard situation. So basically what's happening is that there's already been housing court cases to try to get the landlord to do the repairs, and they're dragging on and affecting this person's ability to be at their job consistently. And it's been really frustrating and there hasn't been much effect. This training is specifically about, like HP lawsuits and harassment. Um, and it feels a little disappointing and possibly, continues to be frustrating for me to say, well, file an HP action. But as far as your question relates to the presentation today, that's the mechanism or possible next step there. If you are filing HP actions for repairs, the repairs have gone on and on. What you're describing seems like repeated failures to repair, and you could try to escalate the lawsuits that you're filing by adding a harassment claim on top of the claims for repairs. I don't really know what to say if you're already trying to do a harassment claim. You know, the the most straightforward path to getting the landlord to do something is to aggressively move towards getting that order from the judge. And if they violate that order, towards filing for complaints, filing for contempt, my bad. Part of this frustration sounds like it might have to do with issues about credibility and what sort of evidence the judge is looking at. I would encourage this tenant to be really creative about what type of evidence they can put before the judge, so that the landlord's lawyers can't get away with lying or misrepresenting the issue. Somebody to try to talk to is the tenant protection unit. You can look up the tenant protection unit and try to contact them about your building if this is a repeated problem, and to encourage other tenants in your building to call in repair problems to 311. Buildings with a ton of repair problems have a chance of being put into HPD's alternative enforcement program, where there's more scrutiny on the landlord.
What is the minimum maximum time between signing a stipulation settlement or receiving a judge's order and filing order to show cause if the landlord is in contempt?
That is going to depend on the terms of the stipulation or the settlement itself. If a lot of settlements have basically like a probationary period, um, a settlement isn't going to be valid if it has a time that a landlord has to follow a behavior indefinitely. It's probably going to say, like for the next year. If the landlord violates the settlement's behavior within the time period that the settlement sets out, um, as soon as the first violation occurs, the tenant can or the occupant can move for contempt. Um, there are practical considerations like, do you have evidence of that? And there's also, a question of how bad is the violation? Do you maybe want to wait and see if you can rack up even more evidence of more violations to get the judge to really be on your side about this? But technically speaking, there's no minimum, in law, there's no minimum amount of time. Another thing to know is that once you file contempt, the landlord will probably be given a short amount of time. Even if the judge finds the landlord in contempt, the judge will give the landlord a short amount of time to make it right when it comes to like repairs and stuff, and purge themselves of any fines that would be applicable. But if it's something like, egregious harassing behavior, then that period where they can make it right might not apply. But the simple answer to your question is that there is no written into law minimum time. It will depend on the terms of the settlement. Also, one thing to flag is that there's a difference between a settlement that is, two parties and is ordered by the judge and is something that's arrived at in the court process, and an agreement that's maybe outside of court or isn't ordered by the judge. So you want to check your case file to make sure that you have a version of the settlement that says like so ordered and has a judge's signature on it. Otherwise, it cannot be used as a basis for a contempt motion.
Is a landlord required to hire a professional contractor to make repairs, or can he just hire anyone to do the job?
I believe that the only type of repairs for which like the law requires particular people, um, you know, assuming you mean repairs that fall short of sort of like construction in the unit, are lead related repairs. I might be wrong about that, but yeah, this is a big frustration. There are not really limitations on who a landlord can buy, and we see time and time again that landlords hire random buddies of theirs or people from around the neighborhood who don't actually know how to do plumbing or tiling, and they do the repairs like they don't know what they're doing, and then you're like, come on. If the repairs aren't inadequate, continue to call 311 and get violations placed, because they're not technically fixed if they're inadequate. And if this goes on, you can file a harassment case for repeated failures to repair. But again, yeah, I think unless it's lead, for the common types of repair problems that you see leading to HPD violations or HP actions for repair, usually there's not a particular license or professional certification required.
If you do live and work and come home on weekends, can you lose your rent stabilized unit?
Okay, so this is pretty off topic to this presentation. The very short answer to your question is that if a landlord can prove that you live outside of your rent stabilized unit for more than half the year, for the what amounts to or adds up to more than half the year, you might be in danger of a non-primary residency eviction lawsuit.
If a tenant believes that the landlord is working with other tenants, using other tenants to harass specific tenants, is there something a tenant can do?
Yeah, this is a really hard situation. And I think one of the things that makes it hardest is the problem of proof. How are you going to be able to prove that this is actually what's happening? And if you can find solutions to that problem, then it's definitely something that you can bring before a judge. But if you're caught in that really common and frustrating place between, you're pretty sure that this is going on, but how in the world are you supposed to find proof for this? I don't have good recommendations for you. You could try to reach out to um, tenant organizers or tenant organizations in your neighborhood to see if you can contact people for sort of like less legalistic support or intervention. There are a lot of different tenant organizations in various neighborhoods throughout New York. So I would reach out to somebody who, if you can't find proof, I would look for less legalistic routes and more sort of like community support routes.
So just to follow up on that, one of the main questions we generally get is that there may not be harassment specifically by the landlord. It may be just like a tenant upstairs or a neighbor tenant that's creating like some sort of noise issue or doing anything else that may be considered harassment, but the landlord is not doing anything to mediate that situation. What can tenants do in that situation? Because I know it can be pretty difficult to make the claim that the landlord is doing the harassment or facilitating the harassment in that situation.
Yeah, this gets really hairy legally, because it's really fact dependent. Um, I'm like trying to think of simple answers, like answers that are easy for me to give. One of the things is that like if the problem is a problem for you based off of like a disability or the disability of somebody in your family, you're entitled to ask for reasonable accommodation and the landlord has to grant that. Um, my office has some cases right now where it really seems like the landlord has probably like hired or let in other tenants in the building that are trying to drive like, the tenants the landlord doesn't want, trying to drive them out. And we're a little stumped too, like how to prove that and how to go about that. Um, Yeah, basically, unless you can, unless you find proof tying that behavior to the landlord itself, you're not going to be able to sue the landlord for harassment caused by other tenants. Um, and housing court is not going to be a good forum for these types of lawsuits generally. Um, Somebody who knows more about sort of like nuisance law or personal injury might have some creative ways that you can tackle the other tenants themselves, but that's not something that housing court provides a lot of avenues for legal pathways for. Um, yeah, I don't know. If other folks have other responses to this, feel free to throw them in the chat. Yeah, basically just to clarify, unless you have specific evidence tying the behavior of those tenants to the landlords, you will not be able to file a harassment case in the housing court for that. That doesn't prevent you from asking the landlord if you can move units or if they can do something about the tenants. And you can try to bring a harassment case if it's really so egregious and the landlord hasn't taken any action. You can try to file a lawsuit under the catch-all, but you're going to need really good proof.
And I think just another question that we ourselves had is that are there any type of tenancies where you can't file a harassment, like 1 to 3 family houses, like tend to have different types of rules than like the
Oh
more
yeah.
bigger units?
Yeah, thanks for asking that. So something that I started to flag earlier on is you're going to have an easier time of winning your harassment case if you live in a building with 3 or more units. And that is specifically because, remember that I said at the very, very beginning of this presentation that the definition of landlord harassment requires that the landlord is doing whatever it's doing in order to get you to waive your tenant rights or put you out. Under the housing maintenance code, if you're if the harassing behavior falls into any of the many categories that I outlined, and you live in a building with 3 or more units, then the court has to assume that the landlord is doing that behavior with an intent to drive you out or to make you waive your rights. So again, if you live in a in a building with 3 or more units in it, as soon as you show that behavior of this type is occurring, then the court will assume that the landlord is doing it with an intent to put you out, and you don't have to prove intent yourself. The landlord can always be like, oh no, we didn't intend to do that, and here's proof, and overcome the assumption. But you benefit from the assumption if the landlord doesn't have evidence against it. If you live in a smaller building with maybe just 2 units in it, then in addition to proving the existence of the harassing behavior, you also will have to try to provide evidence of the harassing intent. And that can be really, really hard to do, because how are you supposed to prove what's going on in somebody else's mind or somebody else's motivations? So specific texts or statements like, I want you out, or like, I'm going to put you on the street is a really sort of like traumatizing thing I've heard tenants say, or landlords say. Statements like that will help you in your case. You are still allowed to bring a harassment case. You just have an additional burden to carry when it comes to the proof. The same goes for retaliation. If you live in a building with 3 or more units, you're going to have a much easier time proving retaliation. You're going to benefit from the law about retaliation. Whereas if you live in a building with smaller units, for retaliation in particular, I'd really recommend you talk to a lawyer about how to prove it.
And this will be the last question, but I think it's personal, but I'll phrase it in a way because I think it speaks to like noise complaints, which we generally get. But a tenant and her family moved in close to me, and they have two dogs that bark continuously throughout the day, especially at night. What recourse do I have as a tenant for my peaceful enjoyment of my unit?
Um, Wait, y'all can still hear me? Did I go on mute?
No, I can hear you.
Okay, okay. So you can always call 311 about noisy neighbors. It's good to do, it's always good to call 311 because it starts to create a written governmental record right away. And something that you can do, like I said, this suffers from the same problems and obstacles as what we were just talking about with other tenants. Unless you can prove something that ties the behavior to the landlord, you can't really sue the landlord for harassment. You can't sue the landlord for somebody else's behavior unless you can prove they work for the landlord or are an agent of the landlord. But if it's so noisy and such a nuisance that you're not getting, I think, right, like you use the term peaceful enjoyment, you're not getting the full value of your apartment, then you might be able to still sue the landlord for, you might be able to sue the landlord for, like, basically what amounts to a repair problem. Or if the landlord sues you to argue that, if the landlord sues you for rent to argue that the value of the apartment was reduced because the enjoyment in the apartment was reduced. So those are 2 possible avenues to take when it comes to a noisy neighbor. And just to reiterate, you could try to do an HP action for her repairs, basically saying like, it's the landlord's responsibility. Call 311, get noise complaints posted, and do an HP action for repair, saying it's the landlord's responsibility to get these people to be quieter. Or if the landlord sues you for non-payment of rent, you can use the implied warranty of habitability, or sorry, in New York, it's just a warranty of habitability, to say that the value of your apartment was reduced by a certain amount, by the noise and how it affected the value of the apartment. Yeah, no, but does that answer that question at all?
Yeah, I mean it answers, I think from my perspective, it answers. I was just like generally talking about the noise complaints and like how it's not always successful in housing court because we're a city of
Yeah,
noise.
yeah. Have you had experience trying to file an HB action for noise complaints?
No, but we've had experience with like other people who've tried and it hasn't always been successful.
Yeah.
Yeah.
Yeah, that's these areas where the law doesn't provide like explicit pathways are areas where combining like a law and organizing approach is probably going to be the best thing to do. And there aren't always or often the resources to do that. But like, this is something where like tenant lawyers would probably want to get together with tenant advocates and like, show up to court, have people turn out to try to like really convince the judge that this is a problem when, the legal claims themselves are a little bit new or novel or something that is less common for a judge to consider. Um, and also something that could maybe be tackled by mutual aid or community support, interventions with a neighbor, and non-legal things. Yeah, unfortunately, neighbor conflicts are just hard to deal with, and the law doesn't provide a lot of avenues. And it'd be really nice to hold landlords accountable, since they're responsible for the buildings. It's just a little harder to do so. For a lot of tenants, it won't be worth the frustration of the process, like the chance that it might not turn out.
Okay, so that's the end of our training. Thank you so much, Cora. It was super helpful. Yeah, and everybody, I posted our phone number. It's 212-962-4795. If you have any personal or for any further questions, and this training will be uploaded on our website. And I will share the information with you, Cora, about the person who asked about the limitations on the judgment.
Okay, great. Thank you. Thanks a lot to Housing Court Answers, and thanks everyone who came and listened. Thanks for your attention and your questions.
Definitely. Thank you so much. And